I gotta admit, I'm skeptical. I don't know. I know it's convenient for students, and students love it. And the applications are gonna go through the roof. We're gonna get so many applications for this. I am just skeptical in 10 years if we'll look back and say that was a good thing or a bad thing. It helps with enrollment numbers, no question, right? People are gonna wanna do it, and they're gonna get their degrees. They'll pass. I don't know what you're getting out of it and what you're losing. Um, I don't know. Maybe even just I don't know, too old-fashioned. I don't know.
They change like the requirements for college.
Starting next year, we have a full-time online program. You'll have to come here. It'll be one week a semester, 100% online. You can be living anywhere in the world as long as you come here. I'm sorry? Yeah, no kidding. No kidding. Chatbots will rule the world. Anyway, again, so I don't mean to grind an axe. It's really not your fault, but we've done Langdell's in person forever, for decades, and for evening students, it worked. You know, people have had kids before 2020, and they had jobs before 2020. They managed. But I guess we've become sort of complacent with the Zoom world. No, it makes it easier without question. I was actually at the open house on Saturday. We had, I think, 400 people come here, and there was one student, very bright. She does patent work. She's like, "Yeah, I live in Houston, but I don't want to commute, so I'm going to do the online program 100%." She literally, she just, "Yeah, I live in Houston, but I don't want to have to commute downtown." Like, she lives like within 610 loop, and she didn't want to commute downtown. And there are gonna be people like that, and it's going to serve a niche, right? It's going to serve a niche. We'll get applications, and I think professors will teach those students. Uh, and it's not gonna be like the Zoom where it's just like you're sitting this one-on-one. A lot of it's gonna be recorded lectures you watch in your own time. So I just I don't know where all this shakes out, and you can sense my hesitancy. Yeah, Nick and Tamara postponed. We only approved it last year. The ABA has to what do you call it? Give like provisional approval, and we only got that last year. No, I get it, and for a lot of people, there are a lot of people sitting. I was actually in this exact room, sitting with their kids and their families, like, yeah, yeah, Nick.
So the flex program is starting this year.
That's probably gonna. I don't want to speak to. That's probably gonna fade out.
What year would they graduate?
That's still 4 years. Well, Flex Evening is 4 years. The Flex Online also, I think, is also 4 years.
So if our master grade for retired schools, that's separated by
Yeah, everything counts. I mean, we can track obviously who's online and who's not, and see if they pass or not. Look, and again, I think bar passage is only sort of the tip of the iceberg. There are a lot of things that happen in law school that aren't about bar passage, and there are a lot of things that happen that aren't about GPA. There are a lot of things. Anyway, I don't want to. Bree's got to go. I've been keep her. Oh, you had class, right? So I've been keep her 10 minutes. I'm sorry. Oh, okay, cluster hall. But anyway, we'll send you a link for Friday at noon on Zoom, at least for this week. And I got to talk to Phil to figure out what happens afterwards. They don't tell me anything. They just kind of just whether it's something I approve or not. So it's sort of anyway. All right, but anyway, Bree's very good. She left, so I can brag about it. She did really well in my class. She's a very bright student. She's also a working mom. She understands how this works. So she will give you the attention you deserve. Okay. Anything else on this online stuff? I appreciate your perspectives, and I was an evening student also when I first started law school, and I worked all throughout law school, so I get it. I've been there. I know where you all are, and it sucks, but there are advantages. All right. Let's do some questions to begin. In our last class, we discussed different types of notice, and specifically different types of constructive notice. This phrase constructive notice was an umbrella term that embraced two types. It embraced record notice and inquiry notice. And a number of you in your little minute polls said you weren't quite sure and you're a little bit uncomfortable with this. So I put together a series of questions, about 4 or 5 questions I want to go through one at a time to sort of tease out the differences between actual notice, record notice, inquiry notice, and so on. All right, so take a look at question number 1. please. Where is it? Where is it? There we go. Okay. Question number 1. You are in a notice jurisdiction, like Texas. O owns Blackacre. O sells Blackacre to A. A does not record. O offers to sell Blackacre to B for valuable consideration. So then question 1A. O tells B that he previously sold Blackacre to A, but A never entered. B purchases Blackacre. Okay, so the question is this. What kind of notice is there? A, actual notice. B, record notice. C, inquiry notice. Or D, B does not have notice. Okay. Who's next? You guys never remember. Sure, Jacob. Linz isn't here, so I'll have to go. Just hang tight. Another 15 seconds. Please put an answer in. Only about half of you put answers in so far. Okay. All right, Jacob. What is your answer here?
A.
Why do you say A?
Because I was telling the, lightly that he already sold it.
He's a crook, right? O is literally telling B, unlike Nixon, right? I am a crook, right? He is a crook, and he's telling, I am selling you the same piece of land I previously sold to A. This is the definition of actual notice, right? Where you're actually telling someone, in fact, I am selling you property that someone else has, and this is 90%. Only a couple people have B and C. Very good. All right, that's actual notice. All right, let's try question 1B. It'll be answered for Victor in a moment. Begins during the closing period. A neighbor tells B that he vaguely remembers O already sold Blackacre. However, the neighbor is not certain. And we learn that B goes ahead and purchases Blackacre anyway. What kind of notice is there? Actual notice, record notice, inquiry notice, or B does not have any notice? Okay. Okay, another 10 seconds. All right, Victor, what's your answer, sir?
My answer is C.
You said inquiry notice. Why'd you say inquiry notice?
Because the hypo gives facts that would lead me to reasonably believe that there's a problem with his purchase.
Very good. Is there actual notice here?
No.
No. There's no actual notice because the memory is hazy, right? By the way, Lavender Haze, that song, I was certain it was about purple haze like Jimi Hendrix and marijuana. I was certain. And I actually Googled it. It's about some period of like love and affection. It's a term from the 50s. I had no idea. Did you just assume it was purple haze? I was blown away. Anyway, lavender, purple. Anyway, so he has this foggy memory. Things I look up, right? He has some foggy memory. No, I didn't buy tickets. I don't care enough. I actually saw Taylor Swift in concert back in 2010 or 11 at Heinz Field in Pittsburgh. It's funny, they actually converted all the men's rooms to women's rooms because usually there were more men's rooms in the football stadium. So there were no men's rooms. Unimportant. During the closing period, right, there's only a vague reference. They're not sure. This is not enough for actual notice, but it is enough for inquiry notice. Why? These facts would make a reasonable person inquire further about this prior transaction. It puts them on notice. Are you going to ask about the closing period? I knew you were going to ask that question. Closing ain't done yet. The closing isn't done yet. Until it's closed, you still have an obligation. And especially if you get this sort of inquiry notice during it and you choose not to act upon it, right? So I anticipate this question because someone asked the same question a couple hours ago. It's during the closing period, right? you still have an obligation to due diligence till you close, right? Especially if someone gives you inquiry notice, that puts you on further notice. If you didn't talk to the neighbor, you just played it cool, you actually been fine. But the fact that you chose to talk to the neighbor and learn this information puts you on notice. This is not a title search. This is an inquiry notice, which means you have to go investigate further, or you have to go ask, "Oh, hey, have you ever sold Blackacre to someone else before?" And then you might engage in some malfeasance. He might be relaxing with non-feasance, just keeping his mouth shut, but he may actually have to either lie to you or tell you the truth, and that might be enough to get him in trouble. And if there's a quit claim deed, right, and you hear this thing, you might just say, "You know what? I'm going to try and back out the deal unless they find some verification for who owns Blackacre." Yeah, the fact that during the closing doesn't change the outcome of the question. It's sort of in there to sort of tweak you a bit, but it doesn't change the outcome of the question. Yes, Emma.
So, if someone just makes mention something that would
Put you on
just look into it.
to investigate further. That'd be inquiry notice.
Okay, because I had in my notes that it was anything related to like any question regarding the transfer of title, like a lost deed or a missing period.
Let me do the next question. I'll come back to your point.
Okay.
The next question I think will help draw the contrast a little better. Will be for Alex in a moment. All right, let's do 1C. Okay. 1C. B is performing a title search. But she's flipping through the pages. And she randomly comes across a deed. Randomly. In which A conveys Blackacre to C. She wasn't looking for it. She just happened to see it while she was flipping through the pages. B, for the life of her, cannot figure out how Blackacre would have been conveyed from O to A, right? So B ignores the issue and goes ahead and buys Blackacre. What kind of notice is there? Answer for Alex in about 20 seconds. Okay. Alex, what's your answer here? Put record notice. Why'd you put record notice?
Because she uncovered something record that should have caused her to ask a question on what was going on.
Okay, good. Emma, what'd you put here if I can jump to you for a moment?
I put record notice, but that's only because I kind of got that feeling that there was something that questioned between the title so that she had to inquire on.
Yeah, right. Okay, good. And that's exactly what I was trying to get for. I think either answer could work here, right? I think either answer could work for. I think record notice is the stronger answer, but inquiry notice could work as well. Let me just explain why. When we say record notice, we are generally referring to something in a record, right? Something that can be found in the town hall, so to speak, right, in the records hall. Is there some record that you found that can lead you to another record that can put you on notice? Inquiry notice is more broadly something that isn't found in records, right? So think of the lost deed in Harper vs. Paradise. That was just missing. That requires some sort of sleuthing, some sort of detective work to figure out what the heck happened to it. You know it exists, but you don't know what it is. With a record search, generally there's something in the actual recorded documents that can put you on notice. But I'll tell you straight up, these two concepts, record notice and inquiry notice, they blur together. It's not always crystal clear which is which, and courts often use these terms interchangeably. So I wouldn't get too hung up on the difference between them. If you say constructive notice, you're probably safe, right? If you want to be more precise, you can. I probably won't penalize you because I think really either one works in many cases. Emma, does that help a little bit?
Yes. But to go.
Yes, but I love it. I love it.
Because I've also put notes about that the law only requires you to check the guarantor guarantee index for notice. So if you were checking the index for notice, that's all you're required to do. So someone just blatantly or just kind of like casually mentioning, I think maybe this happened.
Right.
Is that, are you required to?
Right. So if okay, so let's say the neighbor says, "Oh yeah, I remember that, O sold Blackacre to A," right? And you search all the deeds in the grantor grantee index, and there's nothing indicating that happened. And then you ask, "Oh, hey, have you ever sold this?" And he says, "No." You've done your due diligence, right? You've done your due diligence. But in the first example, if O tells you straight up, "Yeah, I sold this to whatever," and there's no deed that's recorded, you're not going to be able to claim protection of the recording statute if you have actual notice, right? It doesn't matter whether it's in the grant or grantee index. If you have actual notice, you're not going to win. Now let's do question 1D. This will be for Craig in a moment. All right, a lot of people are absent today. I've noticed that row there. Just people aren't here. Okay, so this is 1D. And this is sort of the follow-up to Emma's question, right? So it says B is performing a title search. And she does her due diligence, but she does not find the deed from B to C. I'm sorry, from A to C. Right? She hears all these stories, but she finds nothing. And then she purchases Blackacre from O. What kind of notice is there? Actual, record, inquiry, or B does not have notice.
You said she heard all the stories.
Yeah, and she does her due diligence. She can't find any proof of it.
Yeah.
Oh, yeah, you're right. Oh, you guys are so smart. All right, then answer the questions written. I don't think it matters, but answer the questions written. I don't think it makes a difference, but sure, answer what's on the board. You guys are too smart for me. The polling's still open. Change your answer. I don't think you change your answer. This is based on what Emma asked a moment ago. That's why I changed the question a little bit, but I got caught. I would have gotten away with it if it wasn't for you meddling kids. All right, Craig, final answer. Why do you say no notice?
Well, based on facts earlier, you said you don't need the fact notice, the inquiry notice.
Mhm.
There's some information she's required.
But then she did the inquiry. Yeah. But there's no notice, though. There was nothing there. The neighbors just made it up. Right? The neighbors misremembered. This is an important point. If after doing your due diligence, you still find nothing in the grant or grantee index, this was Emma's question. If you find nothing, you have no notice. You have no actual notice. You've inquired and found nothing. You searched the records and found nothing. Just because a neighbor is talking stuff up and making stuff up doesn't mean it disqualifies you, right? You did your due diligence and you couldn't find any evidence of it. So you have no notice here. Emma, does this make sense?
Yeah.
Does that clean up what you were asking before a little bit?
Yeah.
That's why I have these questions four in a sequence. I knew we were gonna get to this point. I was sort of just dragging it out. Chi, does this make sense?
Yeah, I thought that, because of hearing something, that's like an inquiry.
But you inquired, right? You
Yeah.
did what you're supposed to do. You were a good citizen. You did your homework, and you found there's nothing there. So now you have no notice.
What if your due diligence isn't the correct process?
Well, the due diligence is looking in the grant or grantee index. That's the due diligence. And if you do that and you do it, I mean, I guess if you do a sloppy job, you can prove that. But so you go there, you spend a few hours, you go through the books, and you find nothing. You hire a title company that does it, and they find nothing. What else are you going to do? That you're not expected again to do every single research imaginable. But if someone says, "Oh yeah, I think it was sold to C," right, and you look as best you can, you get finding evidence about C, you're fine. No notice. Blocky, is that what'd you put?
Yeah, but you're saying that,
It would make a difference. Yeah.
so you're saying that even I heard all these things, those things that.
And then you did the research. Yeah.
But-
Right.
And I went and did my due diligence.
Right. No notice. No. Yeah. right? Notice is not like once you have it, you keep it forever. The notice can go away. If you have the duty to inquire and you then inquire and you find nothing, you're clean. You're home free. Which is what we want. We want to reward people, do their due diligence, right? And we want to punish people who hear these stories and then buy it anyway and they don't do their homework, right? You want to reward the person who does their due diligence. Everyone with me? Everyone okay with this one? Yeah, these 4 questions in sequence are designed to get this exact point. That's actually where exactly I wanted to get to, which is why I sort of dragged it out a little bit, but we got there. Good. I mean, let me put this point bluntly. This class, the reason why I think my YouTube videos are successful is because it's a polished production. I sort of know where this is going. Langdells may not have the same, not because this is first time, right? They've not done it before, right? These videos work because there's a very specific plan in place. Okay, like I travel and people I never even met watch these videos. It's just kind of cool. It's my real life. I was at the open house last Saturday and someone said, I've watched all of your videos already. Seriously, she watched all my property, my condo videos. Like, I already watched all of your videos. And she was quoting stuff I said in the videos. I swear she watched them more than you guys do. It's true. No, it was just kind of, flattering. But these videos, it's a production. All right, so let's do question number 2. So we for Jose in a moment. Question number 2. Okay, this one refers back to the prior questions. In which of the previous questions, that was 1 A, B, C, and D, was B a subsequent bona fide purchaser for value without notice, or a subsequent BFP, if I can abbreviate? In question 1A, in question 1B, in question 1C, 1D, or all of the above? Excuse me. I think I have allergies. My throat feels like it's closing up today. Same? Yeah, I don't feel sick, but like my voice is just going all day. All righty. Jose, help us out here. What's your answer, sir? Okay. And so you said question 1D. This was one we just did where there was no notice. Why'd you put 1D? Correct. That's right. The answer is D here. And this, I think, will answer Emma's question beyond anything. The goal of all these questions is to become a BFP, right? The reason why we're asking all these questions is you want to be a BFP. Why? Because in a notice jurisdiction, if you're the subsequent BFP, you win. That's what you want. If you had actual notice, you cannot be a BFP. If you had inquiry notice, you cannot be a BFP. If you had record notice, you cannot be a BFP. The only way to BFP is to have no notice at all. Now, to Flocky's point a moment ago, you may have had something that puts you on inquiry notice, but you lose that status if you do due diligence, right? Something may have put you on record notice, but if you do due diligence and find nothing, you lose that status and you can claim to be a bona fide purchaser in good faith. You acted in good faith, you did your homework, you didn't find it, you can be protected by the recording statute. All this, the reason why you do all this stuff with notice is, are you a BFP? Because if you're not a BFP, you get no protection in Texas. You lose. The earlier in time will prevail over you. Even if you record first in Texas, if you have no notice, if you have notice, you lose. Now, if you're in North Carolina or Louisiana with a race notice, we don't care about the state of mind. If you're a BFP or not, doesn't matter. If you're in California with a race notice statute, even if you're a BFP, you still might lose. But at least in Texas with a notice statute, you want to be the BFP. You want to have protection from the recording statute. You do not want to have notice. And if at some point you get inquiry notice, or if you get constructive notice of some sort, you do your homework. And if you do your due diligence in the proper way, you shed that status. You become once again a BFP with no notice. All right, now we all good, Emma? Yeah, works, falls right into place like a puzzle. Nick, is your hand up or you just? Okay, that's fine. That's okay. All right, I think most of you got that one wrong. A couple of you got that one wrong. Okay, very good. All right. All right. I think we're good here. Questions on the different types of notice before I move on. All right. All right. Let's go. Let's go forward. So you all studied nuisance and torts, I'm guessing. You did Boomer. You did Del Webb. Did you do Boomer? Did you do the air conditioning case? Did you, the feedlot? Feedlot. Okay, good, good. But you didn't do the. So you only did Del Webb. You did the other three. Okay. And Coolander didn't teach us to you guys? I gotta ask. I don't know.
The Sun City one.
You did in 2 other classes. Oh my gosh, so third time's a charm, huh? I'll see if I can drag something new out of it. All right, so let me say it like this. So you all studied in torts, nuisance. In torts, you read these cases for a specific purpose, right? Is there a nuisance? Is it a public nuisance? Is it a private nuisance? Is it an intentional nuisance, right? Is there actually a nuisance? What are the elements of a nuisance? I don't care about any of that stuff. Doesn't matter for me. What I care about is the remedy. And if you look at the way these cases were edited, everything was about the remedy. There was almost no discussion of whether it was actually a nuisance. It was almost assumed. You guys notice that? Maybe you didn't. I don't know, but I did. What I care about here is the remedy. And there are 2. Well, actually, you know what? Let's do this question first before I lecture. I'll lecture after I do this one. Question number 3. I think Jacob might be next. So this is your question. You guys can fight me over the wording all you want. You will. I'm ready for it. I'm here for it. Damages can fully compensate a plaintiff for a nuisance. True or false? I know people are fighting me on the wording. They're just thinking about it. You know. I framed this question several different ways over the years, tweaking words here. I think I've gotten it clean, but you guys are still going to fight me on it. All right. Anyone else? We done? All right, Jacob. What's your answer, my friend?
I put yes.
Oh, that yes was my choice. True. Okay. Yes. Okay. True. Okay. Why do you say yes or true? But the permanent damages fully compensate a plaintiff for a nuisance?
You asked me that makes me want to say no.
I'm asking you the question. I'm not crossing flock again. I'm reading the question on the screen. I'm reading the question fully. All right, Zach, what'd you put? I'm asking what you put. You answered your answer.
Ominous of like I should choose false, but I also chose true.
All right. Okay. Who put false? All right, Chi, you're next. Actually, go ahead.
False because damages make it whole, but it's still there. The damages will persist and they can't go back.
Well, why can't they just take the money and buy a new house? Wouldn't that make them whole?
Because the damage might not.
No, but let's say they get a boatload of money, permanent damages. Can't they just buy a new house, move to Florida or something? I'm talking to him, but yeah, thank you. But would that fully compensate you if you got a boatload of money? What we got? Oh, wow, look at that. That's almost right down the middle. So there's not really a right answer to this question, right? But you can't get it wrong. He's celebrating, right? But if I had to pick one, I'd say false, right? Because I think there are going to be some cases where damages are not enough. Instead, you need, what do you need, Zach? Injunction. if you put either one, I think they're both a reasonable, sensible answers. But I think there are going to be some cases where damages are not going to fully work. You're going to need injunctions. Let me just give a high-level overview, right? There are two broad ways to deal with nuisances. First category of remedies is what you call damages. And the second category of remedies is called injunctions. Right? There are two types of damages we can talk about. The first type of damages is what are called temporary damages, which is sort of a weird word because temporary means like right now, just for a moment. But really, temporary damage refer to past injuries, stuff that happened in the past. The purpose of temporary damages is to compensate you for stuff that happened in the past, right? If there was a reduction in the enjoyment of your property, let's say you had medical bills because of the inhaling all these toxic chemicals and stuff, right? Those are all in the past. Those are temporary damages. But then there's the concept of permanent damages, which Jacob mentioned a moment ago. Excuse me. Permanent damages are prospective into the future, right? The purpose of a permanent damage is to provide a one-time lump sum payment for any sort of future injuries you might occur. Again, that could be loss of enjoyment of the property. That could be if there are any sort of health issues that might arise. But also, keep in mind, diminution in value. If the nuisance reduces the value of your property, that you can't resell it for as much, right? Permanent damages are a one-time payment to compensate you for that reduction in value. Again, it's a one-time payment to compensate you for the reduction in value. So let's say the purchase price for your house was $100,000, and because of the nuisance, it drops down to $50,000. You might get a $50,000 permanent damage award because you're now selling for less. But with the permanent damage, you only get one bite at the apple. Once you get that, you can't go and sue again. You can't go back to the factory or the warehouse, whatever it is, and sue for another one. And your successor, the person who buys the house from you, cannot sue. It's permanent. The person entering that community knows a nuisance is there and can either choose to buy it or not buy it. His expectations are not distorted. I think I know what your question is going to be. Is it going to be someone asked before, I can't remember. Ask it. It's very hard to calculate. So this is similar to what we did before with breach of warranty. We'll do with eminent domain also. When the government takes your property, what do they pay you? Calculating fair market value is very hard. You can look to maybe what property is sold in the neighborhood. There are economists who might make estimates in this regard, but there's no clear science as well. But I'll just compound upon your question, if I may. Sentimental values, right? Let's say your family was raised in this house, your kids were raised there, your grandparents lived there. Not everything can be quantified in dollars and cents. And it's very hard for a court to award permanent damages on the basis of sentimentality. Does that answer your question a little bit? Okay.
Nuisance get significantly worse over time.
That's the question I thought you were going to ask, because someone asked before. Right. If the nuisance gets worse, that it goes beyond the scope of what you agreed to, you can go back to court. But generally, if you're a smart polluter, you enter a stipulation that you can never sue me again for anything ever, no matter what. Right? You'll word it such that you can't come back if the pollution increases by 1 part per million or something.
So are you implying that unless you have damages and an injunction, the plaintiff will never be fully compensated?
Ask me that question in half an hour. I think when we do the 4 cases today, we'll maybe get closer to that. But again, temporary damages are for past injuries. Permanent damages are for future injuries, and everything. It's a lump sum, everything at once. Yes, Flocky.
That already has some,
Right.
so for example, like the feedlot case, and that the purchaser about the settlement, or we need to share that with them.
It's actually a very good question. I don't know that there's the same sort of duty of due diligence that you would look for, because this is not something that's recorded in a grantor grantee index. I think the answer is it doesn't matter, because if they get there and they I'll use a feedlot case as an example. When you move in, you're gonna smell it, right? You're gonna notice it, and if you choose to buy the house anyway, too bad. I think a harder case, let's say that there's only emissions certain times of the year, and when you bought it, it wasn't visible. But the effect is the polluter is immunized. You can't be sued again. So I think you're kind of stuck with it if you don't find out on your own due diligence. Yes, it doesn't sound very fair, does it?
It doesn't, but I guess.
Yeah. There's no like grant or grantee index for nuisances. I mean, in theory, you could search for court judgments on that property, but that's generally not a duty imposed on buyers. Sure.
Well, I understood the question being more is there a duty to disclose like that previous judgment and then
It's not really a covenant, though. I don't know if there's a duty to disclose nuisance settlements, to be completely candid. I don't know there is. If you ask them that and they lie, that'd be malfeasance, right? You can't lie about stuff. But if you just keep quiet, I don't know there's a duty to disclose it. I'm not sure. Yeah, Aaron and Zach.
Curious, I don't recall in the reading ever kind of seeing, permanent damages are kind of like you said, one bite at the apple. But if like, let's say the nuisance is apparent, right, and it's harming your property, and then you settle, and 10 years later you get sick, and the illness can be attributed to the pollution.
All right, let me answer your question two ways. First off, if you know you're living near pollution and you choose to live there after you reach a settlement, that's probably on you, potentially. But the caveat is, if there's something new that could not even been known at the time, you might be able to go back to the settlement. All right, that's damages. You have the temporary damages and the permanent damages. Then you have the injunction, and there really are two types of injunctions you'll learn about. The first is what's called a temporary injunction, right? A temporary injunction might just be during the course of litigation, shut down the factory temporarily, don't emit anything while this case is being litigated. And these are usually argued and briefed very quickly because you want sort of an immediate resolution. And if the court finds that, yes, in fact, there is a nuisance, they can convert the temporary injunction into a permanent injunction. They can convert the temporary injunction into a permanent injunction, which will last forever. Don't ask me about rap. I almost said in perpetuity, and I stopped myself. It lasts basically forever, right? And it's not forever, but that property can't engage in that sort of nuisance again. Okay. So to answer some of the questions before, if you have a combination of damages and injunctions, you can fully compensate a plaintiff's injury. But if you only use an injunction, you really can't compensate for past harms. And if you only use damages, you may not be able to account for all future harms, such as illness and otherwise. So really, I think the only way that courts can get at both past damages and future damages with a combination of injunction and damages. All right. Questions so far? Okay. Yes, Aaron.
Would the terminology present in future damages be acceptable? So like temporary damages.
Just use my words, temporary versus permanent. I mean, it's actually even easy because you have temporary and permanent damages and temporary and permanent injunctions. Actually lines up pretty nicely. It's one of the rare cases where terminology is actually easy to learn. Usually terminology is awful. All right. The first case, let's do it. Morgan, Dominic. Yeah. Morgan versus North Carolina High Penn Oil Company, please.
So the plaintiffs are practice on them.
Okay. And don't say trailer parks. I get in trouble when I say that. So mobile homes is good. I like that. Oh, don't laugh. It's,
And I can, when the, oil refinery goes 1,000 feet. It's like, at least 3 times a week.
right. Now, do you think the company might have offered Morgan some token sum of money to go away and shut up? Maybe, right? We don't really know, but they may have offered something token. He said, forget this, we're going to court. All right, so what did the trial court do here? Again, what was the purpose of the temporary damages? Why would a court issue temporary damages? I just said it many times. What's the purpose of temporary damages? I said it at least 5 times. Aaron? Compensate for past harms. Happened in the past was a compensate for past harms. That's right. Okay, Aaron, so let's move on. What was the other remedy issued by the trial court? I moved to Aaron, I'm sorry. Aaron, try. What was the other remedy issued by the trial court?
It was a injunction.
Permanent or temporary injunction?
It was permanent in this case.
Okay, and so why did they issue a permanent injunction from the trial court? Why didn't they issue permanent damages, temporary damages and permanent damages? Why couldn't they just do that?
In this case, I think given the number of people that it affected, it was kind of a cleaner remedy for the court.
Oh, it's interesting. Cleaner. I like the way you put that. Why do you think it's cleaner?
No pun intended, but like,
Yeah. Funny.
it solved the problem presently and in the future.
Good.
For a large number of people.
Good. Okay, so let me tell you something. At the common law, right? At common law, there's often a pairing of 2 remedies. Courts would usually issue 2 remedies at common law. They would go temporary damages for past injuries, and they would pair that with a permanent injunction for the future, because that covers all the bases. Any past injuries, you're given cash, money. Any future injuries will be avoided because of the permanent injunction. Right? We'll see later in Boomer that they move away from this common law rule. But at common law, you'd often have pairings of the temporary damages with the permanent damages. I'm sorry, I said it wrong. There'd be the pairing of the temporary damages with the permanent injunction. I'm sorry, I apologize. Temporary damages with the permanent injunction. And the Supreme Court of North Carolina affirms. They agree with this approach. The temporary damages is for the past injuries, but the injunction would stop this misconduct in the future. The only way to protect the plaintiffs was through an injunction. Now, Tamara, let me ask you a question, please. After the court issued this permanent injunction, do you think the oil company just sort of shut down and said, all right, everyone, go home? State Supreme Court, they can't fight anymore. Final judgment. What do you think they did? They just shut down the factory and went home? How can they operate? Are they in contempt of court? Are they subject to massive penalties and fines? How do they go about doing that?
They can't, but they probably did.
How? What's the legal way of doing it? I know you're perhaps suggesting that it's some misconduct, but what's the legal way of continuing to operate if there's an injunction in place? So let me say it like this. So the North Carolina court ruled in favor of the plaintiffs, and then they remand, right? And then at some point in the future, the trial court have a hearing, say, okay, I am going to issue a permanent injunction on this date. Thank you. It's called a settlement, but yes, that's right. I am fairly confident that the oil company reached a settlement with Morgan. And Morgan had the ultimate bargaining chip in his hand, the injunction. Because on a certain date, the trial court's going to issue a permanent injunction. And once that's in place, shut down the factory, lay off all the workers, go home. Right? So when you have that injunction hanging over their head, remember the sword of Damocles, right? The sword hanging over their head, right? Which will drop any minute. You pay up and you pay big money. So I'm confident that Morgan and his neighbors in that community probably got a very hefty settlement, right? And it was a lot more than whatever token amount they offered at the outset. When the court gives you an injunction, you get paid to move, go live somewhere else. Now, what if, for example, Morgan was a man of principle and said, I will not move. This is my house, my cold dead hands, right? He's not going anywhere. The oil company has no choice. They can't force him to accept a settlement. Right? But I'll say something you may not agree with it. Everyone has a price. No? Everyone has a price. You just don't know what that price is. If someone offers you some dollar amount, you're going to think very hard before turning it down. You're nodding, Mesa, you agree? Everyone's got a price. So the only question is, how high is the oil company willing to go to get their injunction dissolved? But everyone has a price. Okay. Again, Morgan represents the sort of common law way of deciding nuisance cases. We'll do Boomer later, which sort of goes in the opposite direction. Any questions on Morgan? All right, Mesa, let's do the second case, the one from Houston, Estancias. Give me the facts of that case, please. Very good. And just to clarify, who was there first, the apartment complex or the Schultzes? Correct. Very good. Thank you so much. All right. So here we have a case where the Schultzes are living in their house. Everything's great. And then all of a sudden, a real estate company comes along and builds a huge complex. It was 8 buildings, 150 units, with this ginormous jumbo air conditioner machine, right? Which apparently sounds like a fighter jet or something, right? It's so loud. If you actually go near one of these machines, it's actually deafening to even be close to it. And they're 50, 70 feet away, and it interferes with their lifestyle, right? So is this a nuisance? Sure, right? It's a nuisance. We're not really arguing that. This noise affects their enjoyment of the property. Now, Mike, let me ask you a question. If, let's say you were the real estate company, right? And you realize that you're making all this noise a couple, 10 yards away from someone else's house, 20 yards away from their house. What might you offer to do to make this case go away? You can't fix the machine. Assume you can't easily fix the machine. I think they said it costs $200,000 to fix the machine. Right? Assume you can't install dampeners or noise foam, whatever. Yeah, none of that stuff works, right? What are you going to do if you find out the neighbor is complaining about your noise? What might something you might want to do?
Can't pay for the privilege of annoying them with the noise. That'd be the first goal, right? I guess.
What are you going to I don't know, say it again. I'm not sure what you just said.
I mean, if you compensate and settle with them.
Settle with them, right? You try to make them go away. Buy them a condo like in Bel Air, right? Make them get out of town. But what if they don't agree, Mike? What are they going to do? The Schultzes don't agree to a settlement. What are the Schultzes going to do?
Get rid of it.
And how are they going to do that? What do they do in this case?
I didn't read this case. So I'm behind on my reading.
Okay, you're still here.
I mean, I guess they would try to get an injunction.
Yeah, that's what they did. They went to court, right? Oh, I know you didn't read. You emailed me, but you're still here. So I tried to focus on a question that when required to having do the reading. No, it's no. Do what I can. There was almost certainly settlement talk, right? And they probably threw a token amount at them and said, "Here, your house only worth was it $25,000. Take this money and go away. No lawyers. We'll just make this clean." Right? If you're the lawyer for the real estate company, you say, "Look, just throw some money at them, make it go away." But the Schultz stood by the principle, or maybe they stood by to get more money later. Right? So Kirk, the trial court issued a very curious remedy, or a very like unusual approach to the remedy. What did the trial court do with regard to the remedy? Did you read?
Yeah, I was reading, I was going through my highlights here and everything. So they obviously granted the injunction to start out with, and then,
The trial court. Trial court does something very unusual here.
I thought that they didn't, give the injunction to stop people,
Flocky, what did the trial court do here? It's very unusual. I'm sorry. That's what they did. But before issuing that, what was the analysis? It's something unusual.
Balancing the equities, to determine if.
No, Casey? What did the court give to the Schultzes? Gave them someone. A choice. Flock, you want to try again? A choice. A choice between what? Casey? Correct. The court gave them a choice between damages and an injunction. But the court says they couldn't get both. That is not a common approach, right? Usually the court picks for you. I give an example if you like. Ghostbusters, right? Choose a form of your destroyer, right? Who will destroy you? The Stay Puft Marshmallow, right? How do you want to win? Not a bad analogy. I love that movie, right? What remedy do you want? So they gave him a choice, and indeed, the Schultzes chose an injunction. So Kirk and Flocky are correct, but it was only because they chose that. They could have chose damages. Now, in hindsight, they chose wisely, as they might say, right? They made the right call. Right? Why? If they got damages there, the case would have been over, and they would have just gotten some money. But instead, they got an injunction. And an injunction is much more valuable than damages. Kirk, why is an injunction more valuable than damages?
well, in Texas, because of the Spur case, there's to kind of make them heritable, or I guess to balance.
My question: Why is a injunction more valuable than damages to the homeowner?
Said, like, damages pulled the injunction over their head.
You extract a massive settlement from people making the noise, right? The injunction's worth a lot more. If you're the homeowner, you want the injunction because you can use that to extract a high settlement. If you're the nuisance maker, the nuisancer, the people making the nuisance, you want damages, pay them to go away, right? So the trial court issued a very valuable remedy, which was an injunction. Okay, Flocky, what happened on appeal? What did the Court of Appeals do? Okay, why? Why? Nick, what did the Court of Appeals do?
So, we also left open the fact that, they could probably bring in
let's talk about the injunction. Was the injunction proper? Sure. Why sure?
So it says, so they based this on the story case, and that, the Stern rule of necessity.
How did the lower court balance the equities, Nick? What are the equities in this case?
Equities are the, right to enjoyment for.
So if the court issues an injunction against the apartment company, who benefits and who loses?
Benefits the neighbors.
The Schultzes,
Schultz.
right? Who loses? And tenants. Why did tenants lose? They have nowhere to live. If they actually have to replace all the air conditioning, for some period of time, these places will be uninhabitable. If you're in Houston, you can't live without AC, at least in the modern era, right? You can't have that. It doesn't exist. So all the people who live there would lose their homes. Likewise, in Morgan, if they shut down the oil company, all the people lose their jobs. Like in Boomer, if you shut down the cement factory, all the people lose their jobs. So one second, Nick. On one side of the ledger, right? So on one side of the balance sheet, you have the landlord and all the people who lose their homes. On the other side, you have the Schultzes, a family of what, 2 people who would live in a small house. Ryan, how do you balance the equities there?
So the court just, I think the only thing that they really wanted to make sure was that the plaintiffs' damages or the amount that they were suffering from, basically that their amount that they wanted, if that was insignificant in comparison, or just in general, then they could deny it.
Does it matter that a ruling for the Schultzes results in hundreds and maybe even 1,000 people losing their home? In other words, to benefit 2 people in the Schultz home, you throw 100 families out of their apartments. Does that matter to the court? Okay, this is the common law way of thinking. It doesn't matter, right? When you're balancing the equities, you're looking at basically does this create a nuisance? Yes, issue the injunction. Shut down an oil company? Don't care. Issue the injunction. Kick 100 people out of their apartment? Doesn't matter. Issue the injunction. This was the common law way of deciding these sorts of cases. The remedy was an injunction, and once you have the injunction, if it's really that valuable to the polluter, they will reach a settlement with you. One second, Casey. And that's exactly what happened here. Do you think for a second that after this case was decided, they just evicted all their tenants and suddenly, spent 6 months and 200 grand putting a new AC in? No, they just paid off Mr. Schultz. And they found some dollar amount that was worth it. He had a price. He stood for his principles in lower court, but my friend had a price. He bought a nice house somewhere by the beach, right? Whatever the dollar amount was, it was something less than the $200,000 for sold new AC. Casey. Casey. Oh,
I would present that to, maybe, I would think since the apartment stayed second, that the Schultz would have came to the nuisance and they the apartments actually came after the Schultz.
right, the Schultzes were there first.
Yeah, so then they came and built the
Yeah.
nuisance, they actually caused it.
Correct. Yeah, this is not a coming to nuisance case.
Yeah, so with that being stated, they caused the issue, they should have had the foresight to remedy it before it even got.
Well, again, but how do you remedy it? To use damages or an injunction, right? There are 2 ways of remedying an injury. They could have just paid Mr. Schultz enough to buy a new house and they could move, right? They could have done that.
But I thought they said that before they started building, that they knew for the cost of rent, like maybe 40,000, they could have made.
Oh, you're saying so might be bad faith?
Yeah.
Maybe. Yeah, maybe if they had taken the precautions earlier, they could have gotten off cheaper. Yeah. They were going to lose, right? The only question is whether they lose with damages or lose with an injunction. That's the question. Like, how do you want to lose? Believe it or not, the Supreme Court of the United States will often ask that. They'll ask the party, how do you want to win? Because there might be different grounds. And they'll ask the losing party, how do you want to lose? And they'll often pick the way to lose with the least collateral damage. So you might ask by judgment, how do you want to lose, counselor? That's a good question. It's a terrible question to be asked, but you have to make sure you answer it carefully. All right, so here again, the court follows a common law rule that an injunction was proper, even if it would harm hundreds of families who are living in those units. Nick.
Did it say that there were hundreds of families? Because if it was too loud, the neighbors.
Well, it says 150 units. I'm just guessing 100 families. Right. So I'm just making up the numbers. It's not terribly important. But I mean, imagine that the units are probably sufficiently far away from the AC unit. Oh, you think that maybe it wasn't so loud?
I just think it'd be. Yeah.
Something fishy. Something maybe smells bad, right? Like in the feedlot. All right. All right. Any questions on? Yes, Mesa. That's usually done, right? But it's done in a very unusual way. They don't really care about the equities for the defendant's business. They only care about the equities for the plaintiffs. It's sort of the common law approach was stacked for the plaintiff with the injunction.
This case did say it was kind of like
A floor of what?
if there's like some sort of limitation and like on the lower level.
You're talking about, are you actual damages, permanent damages? What are you-
The value of this thing.
Not enough for an injunction, right? I mean, that gets to a question: is there actually a nuisance? If it's just it's a couple of decibels over ambient noise, it might not be enough. Okay, Asan, can you give me the facts, please, in Boomer?
Yeah. The Atlantic Cement Company, they own a large cement plant on Whiteacre. Boomer maybe Whiteacre. Boomer was saying that there was alleged injury from dirt, smoke, and vibration emanating from the plant.
Mm-hmm.
Boomer saw damages for path losses and the junction.
Okay.
Junction would have required the plant to shut down, and I guess Atlantic had invested quite a bit.
Millions, yeah. Yeah, millions of dollars. Go on.
$1 million and employed 300 people.
Okay.
The trial court granted damages to Boomer, but they denied the injunction.
Ah. Why didn't the trial court deny the injunction?
Because of the economic benefit, I guess.
That's different than what happened in Texas, isn't it?
Yes.
Right. So these cases are back to back in your book for a reason, right? The Estancias case illustrates the more common law approach, where you don't really care about the economic consequences. The New York case, we'll go to the New York decision in a moment. New York is more of the modern trend. Remember, the common law goes to die in the Northeast corridor, right? In this case, the damages would potentially make Boomer whole, but an injunction would result in hundreds of people losing their jobs and shutting down this productive facility. Now, in New York, the precedent actually was in the opposite direction. But if you read the majority opinion carefully, like, well, we have these precedents, but we're not going to follow them. Welcome to New York, right? The court says permanent damages can cover Boomer's past and future losses. So going back to our question a few minutes ago, if you're the New York Court of Appeals, how are we answering this question? True. If you're in Texas common law, how are you answering this question? False. So that actually might help you even more with the answering this question, right? In New York, they say that the damages can cover both past and future losses. And even if there's no injunction, you can still do justice, right? All of Boomer's economic losses will be addressed with damages. Moreover, if there's a damage award, it prevents future recovery by Boomer or other residents. Again, if there's for permanent damages, that's it. There's no more liability for the oil company, for the concrete company. All right. Yes, Tamara. Right. As far as I know, Estancias is still good law. I don't know that's been overruled unless someone tells me otherwise. So I think yes. You know what? let me revise what I just said. There was a case in Houston that you may be familiar with called the Ashby High Rise case. Anyone know about this? Yes. If you ever drive by Rice University of the Museum District, the corner of Ashby and Bissonnette, you ever go there? I have it on the. I forgot to mention my earlier class. I'm sad. I'll mention it here because Tom reminded me. This is going on for more than a decade. You may be seeing these signs around town: Stop Ashby High Rise, Tower of Traffic. So at the corner of Ashby and Bissonnette, this is more than a decade ago, we were planning to build a high rise right near Rice University, and the neighbors flipped out. Right, and the neighbors opposed it, and this was a very affluent neighborhood. They said there'll be noise, there'll be traffic, there'll be shadows. They raised everything you can imagine. Now Houston has no zoning code you may be familiar with, so there's really no approval from the city needed. But they sought every type of approval. They wanted a noise survey, all this stuff. Finally, when all was said and done, they brought a nuisance. And they claimed that the tower was a nuisance. Okay, what was the basis of the nuisance? This building was out of place. It didn't fit in with the surrounding neighborhood. Now, that's not a nuisance by any definition I've ever seen, right? Professor Festa, who litigates this case, has argued this very effectively. But the court found it was a nuisance. And what remedy did the court order? The court did not order an injunction barring the construction of this tower. Instead, the Texas court, the trial court, ordered permanent damages to the neighbors. And they calculated the permanent damages based on the diminution of value of their property. That is, what's their property worth today, and what would the property be worth if this tower is built across the street and there's shadows and noise and traffic. Now you're going to ask, Josh, what happened on appeal? The case got very messy. The lot is actually still empty. Nothing's ever been built. I don't have a clean answer for what happened on appeal because it's not entirely clear to me. But at least the trial court seemed to follow Boomer. Right? So when you ask what the common law approach is, I don't know that it's strictly followed anywhere. Right? Judges still have discretion in equity cases. But at least in the Boomer case, the Ashby High Rise case, the Texas trial court followed it. It went up on appeal and didn't get really resolved cleanly, but that's the short answer. Did that make a little clarity for you? Alex, please.
I grew up 2 blocks away from this site. And
Oh no, you one of the nosy neighbors?
well, it's kind of funny because there was an apartment complex there.
Yes, it was. And he demolished it.
Yeah. I think they might have settled. The original developer gave up, and this
Yes.
is a new developer.
I think that's right.
And to please people, they basically, the old apartments were like normal apartments, and these are like huge apartments. So the building is big, but it's gonna have like.
But it's still empty. If
80
you
people.
drive past it, there's nothing there. I started teaching in 2012. It's been pending for a decade. That lot's been empty. In fact, there's actually a video of it on YouTube. You can find it. I was much skinnier and has a far less hair. But I was standing in the lot where the old Ashby High Rise was, just taking pictures of all the apartment buildings. Casey. All speculative. It's 100% speculative, right? For all we know, having that property there will increase property values. We will do later this semester the idea of zoning. And one of the core reasons why we have zoning is to maintain property values. And all these people think, if we restrict the colors and the size and the different building materials, we'll keep property values up. Is there any way of proving this? Of course not. If they're wrong, the predictions are wrong, can you undo it? No. Right? But at least governments give deference to entities when they say this will raise our property values. I was teaching this case maybe 8 or 9 years ago, and I was saying, these busybody neighbors, and I was sort of just talking smack about them. And one girl sitting right in the back row said, "Yeah, my dad's one of the lawyers." I'm like, "Oh, great." Anyway, I can't remember. I have tenure. I didn't have tenure then, but anyway, I don't care. Yeah.
They actually got a result. They got an ordinance passed that like now high rises can't be built within like 20 feet of a property line. Like they did lobby like city council, and they did get like an actual thing that affects development.
Okay.
I don't agree with it.
Yeah, son.
If I have a plot of land, it's like, and there's litigation because of it, like, is
there like some relief I get for paying tax on it? I'm carrying one.
Well, that's what I don't fully understand. Nothing's happened, right? That this land has been sitting vacant for a decade, and I don't know what the valuation is because there's nothing on it. But it's in a very expensive area of town, so I have no idea. They've taken a massive loss on this property.
That's what,
Yes, Craig.
all the bills have been exhausted, they're gonna start building it today.
Is that right?
Correct.
Where'd you see? So that just
I can't remember, I heard of it, it's.
look. I'll believe when I see dirt being moved. I seriously, I've been hearing.
There for a year.
I've been hearing this for like 11 years. I think I start building any day now. So I think all the appeals been exhausted. To Tomer's question, they paid the permanent damages. So, but my point is there was a settlement, so there's not a clean issue of whether the trial court got the law right. I think that's more concerned about. But yeah, we'll see. Maybe we'll take a field trip there in May. All right, Emma. Last question, then we have to do the feedlot case. Yeah, it's one at a time.
But now then can compensate the
Correct.
nearby neighbors.
Right.
Is this kind of like the court just preemptively thinking about how you mentioned for like the oil refinery? Or like, I mean, they did an injunction, but then
They knew what was going to happen.
almost
Right. Yeah. Emma's a very good question. Let me make sure I answer it carefully. The judges in New York are not dumb. They know full well if they issued an injunction, the cement company would have paid off Boomer, right? Because that's what happened in North Carolina. So they sort of cut out the middleman and said, you know what, just pay him and be done with it. They're saying no one's principal is worth that much money. And they cut out the middleman. But I'm certain that Boomer would have gotten more if he had an injunction in his back pocket. He could settle for a lot more. He probably got less because of this. One other point, generally nuisance litigation for environmental stuff doesn't happen today. And the reason why is we have environmental laws, right? State and federal laws prevent emissions into the air, emissions into the water. The government can come in and take enforcement action to the Environmental Protection Agency and other agencies, okay? Why does it matter? Everything's flipped. In the olden days, you could keep polluting until some court told you to stop with a nuisance action. Now, you can't start polluting unless you get the permission from the feds, right? You can't build, you can't get a permit, you can't assemble a power plant until the feds approve your design. So it's no longer the burden of the neighbors bringing this litigation. With environmental laws, the burden's on the polluter not do these things that are barred by law. So this case was from the 70s. These are when these federal laws were being created. So the Boomer case doesn't have much juice anymore because you would not have a cement plant opening up without being subject to massive regulation by the state and the feds. That makes sense? All right. Am I you next? And then, I don't know, Sean, I think you're next. You're all alone. Your friends aren't here. The row's empty. All right. Do you want to give me the facts, please, and Spur? We're a little bit short on time, so.
The Spur Industries operated a tunnel to and allow millions of tons of material a day. Del Webb Development Company has owned the parking lot and then the village to meet the senior citizens. And soon Del Webb began to develop homes close to the street on the unfinished away from it. Eventually the owners started to become serious problems, and there was a lot of fly that would drift over to the lot. This resulted in 1,300 of the Del Webb homes not being sellable.
Good.
Because they were unfit for development.
Good.
Because of this lot.
Okay, very good. So here we have the classic coming to the nuisance case, right? Without question, having a feedlot near residential communities is a nuisance, right? There's a statute governing it. There's 1 million pounds of manure produced, whatever the number is, an obscene amount of manure produced every day. Anyone ever work in a feedlot? It's not good of a student. Okay, fine. There's a nuisance. But then we get to the question of remedy. And the court does something kind of unique here. Emma, what does the court do with the remedy here?
The trial court issued an injunction.
Straight up injunction.
And then on appeal, they started to look at how it was affecting
if it was like a private nuisance or a public nuisance.
Okay.
And then they eventually decided that um, Del Webb had built homes in this area that was next to the feedlot.
And did he know the feedlot was there?
And they knew the feedlot was there.
So is he a good faith actor here?
Probably not.
And this is Casey's question from a few minutes ago. With Estancias, they knew they could have built it for cheaper. I'm sorry, for a quieter system for a little bit more money. So, right. So, what does the court do with the fact, Emma, that he deliberately, knowingly built it where it was uninhabitable next to the manure stuff?
Well, they put some liability on the developer and said that they would pay for the feed company to move it.
Correct. That's how the courts are split the difference. So they did a curious spin. Usually you enter either an injunction or damages in favor of the plaintiff. But here the court entered an injunction in favor of the plaintiff, but imposed damages to be paid to the defendant. Right? What had to happen was the defendant had to, I'm sorry, the plaintiff, the real estate company, Del Webb, had to indemnify Spur. Indemnify means to make whole. So whatever costs that Spur incurred by moving their heads of cattle who knows where would be borne by the real estate company. In other words, there's a nuisance. It has to be abated. But the cost of that abatement would be covered by those who came to the nuisance. Those who knowingly built there, almost like a bad faith argument. I'm sure the court would have said, you know what? You decided to build a community next to a bunch of manure lots. That's on you. But they couldn't. They had to grant the injunction under state law. But they could sort of split the difference and issue the remedy where the developer has to pay the costs of the feedlot to move. And that was probably significant. Moving all those cattle is not cheap, not easy. I have no idea how much it even costs. And by the way, if you know someone's paying for you to do it, you're probably not going to do it on the cheap. You're gonna do it. You're gonna pay your buddies. There's probably some kickbacks. You know how that goes on the ranch. Okay. What was that, Victor? How it goes. All right. So questions on Del Webb. Kirk.
So the reason that we're soon be enjoying was that it wasn't in the public health realm, or it wasn't-
Right. Yeah. I mean, this is probably both a public and a private nuisance in my estimation, because it affects the health at large. And there's a specific statute saying you can't have residences near a feedlot because it's such a known spreader of disease and bacteria. You don't want to live near there. Okay. So to summarize, because Del Webb acted in bad faith, they came to the nuisance, they have to pay. All right. All right. Questions so far? Casey? Yes, because they came to the nuisance, the plaintiff is liable for damages to the defendant for his relocation costs. Good. All right. So again, to summarize, when we're talking about the remedy, the common law approach we saw in Morgan and in Estancias, which is that you can enter permanent injunctions without regard to economic consequences, and you pair that permanent injunction with a award of temporary damages. The more modern approach, we saw this in Boomer, is to enter both temporary damages and permanent damages, but not the injunction. And at least in the Del Webb case, the court kind of got creative and entered a permanent injunction coupled with reverse damages in favor of the defendant. Okay, questions? All right, I'm sorry? We will do zoning at great length later this semester, I promise. All right, anything else?
Or an injunction, temporary,
At common law, the pairing was permanent injunctions and temporary damages. That's right. That Webb, they did it backwards. They issued a permanent injunction with damages for the benefit of the defendant. Okay. All right, I shall turn the exit polling on. Have a wonderful day, everyone. And I will get more clarity on the Langdell for Friday. I'll get to the bottom of this and see what we can do. All right. Thank you so much.